Okay. I'm hoping Jennifer is here. So it's my pleasure now to introduce our first speaker. Backed by popular demand, it's my pleasure to introduce Jennifer Duff. Jennifer is a labor lawyer with Shields, Hunt, Duff, Strachan. Jennifer practices in all areas of labor and employment law with a focus on representing unions and their members, as well as employees in employment law matters. Jennifer ensures that clients understand the legal process and feel comfortable and confident as possible as they navigate through the various stages of litigation. She appears in matters before federal and provincial courts, boards, tribunals, and arbitrators on behalf of public and private sector unions and employees. She is fluently bilingual and serves clients in English and French. A partner in the firm, Jennifer was called to the bar in the province of Ontario in 2003 after articling with Shields and Hunt. Jennifer graduated from the National Program of the University of Ottawa, receiving her Common Law LLB, cum laude, in 2000, and her Civil Law LLL, summa cum laude, in 2002, and I hope I came close to pronouncing those things right. Outside her law practice, Jennifer spends her time enjoying the busy life of a mother of 3 active children. Jennifer enjoys traveling with her family and experiencing what the world has to offer. Please help me welcome Jennifer Duff.
Thank you. I'm thinking I'm going to have to update my bio there at one point because it used to be fine to say when I graduated. Now it makes me just feel a little bit old. So, okay, so I am here to speak to you about harassment and workplace violence. And let me start with this. I'm very, very happy to be here today with all of you in person. I think the last time I came in person was 2019, so it would feel like 2.5 years ago. It feels like much longer. And before we get started, as a heads up, you should all know that I'll be going back and forth in English and in French. And so for anyone who needs them, you'll want to have your headphones ready. Donc je vais faire ma présentation et en français.
So I'm going to be presenting both in English and French. I'll be going back and forth. So for those of you who would need them, please make sure to wear your interpretation kits.
For me is always the slides. And Lyra assured me that both will work with the same button. So let's go. There we go. I love it already. Okay. So d'abord, un petit peu de contexte.
So to provide you with some context, employers for quite some time now, I think I should have taken off my mask, sorry. So for quite some time now, employers had an obligation to maintain a healthy and safe workplace and to investigate complaints of harassment or violence in the workplace. But on January 1, 2021, the federal government put in place the new Workplace Harassment and Violence Prevention Regulations, known as the regulations in the workplace. So it's very, very long. So I'm going to be referring it to I'll be referring to it as the regulations. So the regulations brought some amendments to the Canada Labour Code under Bill C-65. So these amendments significantly expanded the obligations of federally regulated employers with respect to preventing harassment and violence in the workplace. And the regulations equally outlined the procedures that must be in place in order to respond to incidents of harassment and violence. So basically, under the new regime, the existing Canada Labour Code provisions with respect to sexual harassment and violence were consolidated and broadened under Part 2 of the Code. Federally regulated employers are therefore required to comply with a number of obligations in order to satisfy their duties under the Code, which are to investigate, to record, to report, to prevent and to provide as much as possible training with regard to workplace harassment and violence. So this equally includes sexual harassment and sexual violence. So in a nutshell, employers are required to prevent incidents of harassment and violence. Secondly, to respond effectively to these incidents if and when they do occur. And thirdly, to support affected employees. So the regulations apply to all workplaces that are regulated by the Canada Labour Code. I mentioned this earlier on. So what we are referring here to is the various branches, agencies, and ministries of the federal government, as well as federally regulated workplaces, which include the First Nations band councils, banks, telecommunications companies, and obviously air transportation, as well as interprovincial and other transportation such as railways. I'd equally like to mention here that the new regulations only apply to workplace violence or harassment occurrences that happened on or after January 1st, 2021, and occurrences that the employer first became aware of on or after January 1st, 2021, even if the incident happened before January 1st, 2021. So for every event that the employer only learned about before January 1st, 2021, you need to use the processes which were mentioned in the previous regime, so the regulations on workplace health and safety.
And switching the slide over. So before we really get started into the sort of the nuts and bolts of the process, first question, what is workplace violence? And so part 2 of the code, the Canada Labour Code, defines harassment and violence to include any action, conduct, or comment, including of a sexual nature, that can reasonably be expected to cause offense, humiliation, or other physical or psychological injury or illness to the employee, including any prescribed action or conduct or comment. And so that's a mouthful. I'll just take a sip of water here. And so what does that really mean, right? And so I'm going to show you some examples. I'm not going to go through these, through all of them, and you will get a copy of these slides with your notes. But before you, you've got a non-exhaustive list of what may amount to harassment and or violence. So, aggressive or threatening behavior, including verbal threats or abuse. Physical assault, obviously. Spreading malicious rumors or gossip about an individual or about a group. Socially excluding or isolating someone. So that one's a tough one. Sometimes when I'm not wearing my lawyer hat, I'm wearing an investigator hat, and in conducting workplace investigations, what we find is that's a very tough one to prove. Not that it shouldn't be alleged and not that it shouldn't be sort of, very much looked into, but it's sometimes tough to distinguish between two people who just don't get along and don't eat lunch together and don't really speak to one another in the office or in the workplace, and, a targeted attempt to socially isolate somebody away from the rest of the workplace. Other examples, abusing authority by publicly ridiculing or disciplining a subordinate. We see that sometimes in the workplace with some managers or supervisors with very aggressive or very even loud sometimes personalities. Abusing authority by interfering with a subordinate's performance or their job, so blocking applications for leave or training or promotion. Making abusive or derogatory remarks or jokes about someone's gender or gender identity or gender expression or their sex or sexual orientation. So for example, making homophobic or transphobic remarks. So Domestic violence. And so this is an interesting aspect of this. So it's also called intimate partner violence or domestic abuse or relationship abuse. So that's a workplace hazard. I mean, obviously it could be two people who are in a relationship working together, but it could also be coming from outside of the workplace. So it's considered to be a workplace hazard when it occurs in the workplace. So it puts the targeted worker at risk and it can pose a threat to coworkers. We see this kind of thing sometimes with just one example, a relationship ends and you've got somebody who's in the workplace and their former spouse or their ex will call or will, purposely, they will call to track, they'll call fellow employees, other people they know, or they will, purposely not be available to pick up the child at daycare, those kinds of things. Those things have ramifications, obviously, inside the workplace for the worker who's experiencing that domestic violence outside the workplace. Using the internet to harass or threaten or maliciously embarrass someone. We see that time and time again now. People, behind the anonymity, or people are much bolder when they're typing behind a keyboard than they are in person. So we see Facebook harassment campaigns or Snapchat for younger people, those kinds of things. And obviously, other examples would be sexual touching, so patting or pinching or caressing or kissing or fondling. Even if you're wearing the green button, these things are not acceptable. Sexual invitations or requests in return for the promise of a reward. So that's the classic, what we used to think about sexual harassment. Sending inappropriate electronic communications, so sexually suggestive or sexually explicit emails to people. Don't do that in the workplace. And I tell my children, don't do that, ever, but that's a different story. Okay, so we've heard about things that are harassment. What's not harassment, right? And so we are asked not to confuse, and sometimes it's hard, but not to confuse workplace harassment and violence with normal workplace conflict and differences of opinion, right? And it's been found, the cases, court cases, arbitral decisions over the years, it's been found to be appropriate for supervisors to take the following actions, as long as they are done respectfully, professionally, and in good faith. So supervisors can directly supervise employees. They can set out performance expectations, and they can provide constructive feedback and about their work performance. They can put employees on performance improvement plans. They can take reasonable disciplinary actions, and they can assign work, and direct how and when that work ought to be done. Or they can request updates, or they can approve or deny time off. Again, I think the key word here is the reasonable and in good faith. Bon. Donc là, on rentre vraiment dans la...
So here we are getting really into the nitty-gritty of the regulations, and we're looking at what the regulations require of employers. I'm going to look at 4 different aspects with you. The first being to put together a policy. We must offer training. We must equally conduct an assessment, a risk assessment in the workplace. And finally, we should be able to resolve complaints or grievances. So we'll start with the policy, because this is a starting point. So employers, as well as their partners, the concerned partners, must together make sure that they come up with a workplace harassment and violence prevention policy, and also to provide this policy to employees. So you see that I already talked about the partners concerned. So the policy uses a very specific terminology. So concerned partners here simply referring to the consultative or the committee with regard to workplace safety, occupational safety. So it depends on the title which is used by the employer, but there's always a partner or a committee that is established in order to work on the workplace safety piece. So the policy must contain a number of aspects, especially including a statement of mission statement from the employer on the prevention and protection against violence and harassment at the workplace. The policy must describe the respective roles of the employer as well as employees and the partner involved. The policy must outline or summarize the training that will be offered, the process for resolving complaints, as well as emergency procedures, and the way in which the employer intends to protect the private lives of the persons involved. More and more, we're beginning to to see anonymous reports where you within reasonable, as much as possible, there are no items identifying individuals in a specific manner. I'll come back to that particular aspect down the line. The policy must equally describe the different resolution processes or the different recourses that are available, and also the support or procedures that are available to the employees, as well as the names of the persons who are designated to receive and listen to complaints. So this is often the designated person to listen to these complaints. In our case, we have Sean and Colleen, who will be listening to any harassment complaints. So we'll equally be talking about offering training. So what is supposed to be contained in this training? This training is supposed to be offered to employees within 3 months of them beginning work. Everyone should have received training before January 1st, 2022. And in this training, the training must include aspects of the policy, and you must be provided with a description of recognizing, rather differentiating workplace-related conflicts and harassment and violence at the workplace. We equally need to be provided with information on how to recognize, minimize, and prevent, as well as respond to workplace harassment and violence. Another obligation for the employer under this regulation is to conduct an assessment of the risks at the workplace. So employers, as well as their partners, the concerned partners, must assess and identify together the risk factors which could be either internal or external to the workplace. And these risks will largely contribute to harassment and violence at the workplace. So as part of this assessment, we must factor in the culture, workplace culture, work conditions, as well as the organizational structure in the workplace. We must equally pay attention to outside external circumstances, such as the family situation, which could lead to incidences of harassment and violence in the workplace. You also want to be able to take into consideration all the reports and data relating to workplace-related incidents of harassment and violence. You're equally looking at physical conditions at the workplace. There are certain workplaces which are more likely to lead to or to encourage, so to speak. It's a bit strange to say it that way, but which could lead to, incidences of violence and harassment. And equally to look at the measures in place in order to protect the health and safety, psychological health and safety of workers in the workplace. After conducting this risk assessment, every 6 months, each 6 months, this assessment must be conducted, and employers, as well as their concerned partners, must come up with and implement a number of preventive measures in order to address these risk factors. The resolution process. So finally, the regulations put in place a resolution process which is quite detailed, and that is what I'm going to be talking to you today about. So the regulations provide employers with detailed and comprehensive resolution process, and the regulations set out timelines, conditions under which the processes are to be used, and the steps to be followed as soon as a notice of occurrence is served.
So listen, let's get the process started. So who are the parties? Who can initiate a complaint? And as I had mentioned earlier, the regulations require an employer to designate a person or a division to receive harassment or workplace violence complaints and to coordinate the complaint process. So this is called the designated recipient. And you'll also hear words like principal party and responding party. So the individual who has been allegedly targeted or subjected to harassment or violence is called the principal party. And the person alleged to have been responsible for the harassment or violence is the responding party. So it's very hard to get used to this terminology. We will often refer to those parties as the complainant and the respondent. Most of you will have heard that terminology and be used to that as well. But when we're dealing with code complaints, you'll see this terminology being used. And I suspect that this is at least in part because a principal party can make a complaint on their own behalf. And in that case, they're the complainant. But a third-party witness can also make a complaint on behalf of a principal party. So if a witness brings the complaint forward, the witness can remain anonymous, but the principal party does not remain anonymous. So that's an interesting feature. I think that's why the principal party is not necessarily the complainant. And an interesting feature to know is that under these regulations, former employees are also permitted to bring complaints forward, but they have 3 months to do that following the end of their employment. Okay, so how does the process get started? And I can you guys can read it here, but I can summarize the start. So before we really get going into how all of this gets going, how the process gets started, what you need to know, and I think we heard it already today a little bit, is that ideally these things get started as quickly as possible. So once an incident occurs, you want to signal it, you want to raise it as soon as possible after the incident has occurred. And what this does is it permits an employer to deal with it as quickly as possible. Now, I say this, if there's an immediate danger of violence, so to life or limb, or if there's a situation that is putting the safety of a person in jeopardy, of course, what the employee is supposed to do, or ideally you have to try to disengage from the situation, you get yourself physically away from the situation. And then you call 911 if you need to call 911, you get medical assistance, and then when you're in a safe space, that's the point at which you would identify, or you'd give the signal that the incident has taken place. So safety first, and then you go ahead and start that process. Okay, so under the regulation, a complaint, again, different wording, the complaint is called a notice of occurrence. So the complaint resolution process becomes engaged as soon as a notice of occurrence is provided to the employer or to the designated recipient. So there's no requirement of a specific form that needs to be used, but many employers will have forms internally, they will have developed forms, but the complaint itself does have to contain the following. So the name of the principal party or the parties, if known, again, obviously, if it's your own, you're going to know, but if it's a witness that's making this report, they may not know the name of the individual. The name of the responding party or parties, again, if known. The date of the occurrence, and then a detailed description of the occurrence. We always tell, and I'm sure you all do this as well in your own work lives, we tell people keep notes of dates, keep notes of times. So this continues. We do this to the extent possible. Keep notes of everything. In terms of the detailed description of the incident, I normally tell people you don't have to give a 14-page complaint document at this stage. Because sometimes it gets handed over to the responding party, sometimes it doesn't, it goes to the employer. But what happens ultimately, if this goes to an investigation, sometimes it contains a whole bunch of extraneous information, and people want to get their stories out. And I always tell people, stick with the facts for now, and the time to get your story out is when you're meeting with an investigator, and you will be given the time to start at the very beginning and to go through. You still have to name the incidents. You don't give so little detail that there's nothing to go on, but you don't have to give, you don't have to write a novel about it at this stage. So I'm going to show you an example. I'm sorry for the tiny font, but this is an example that is on the Government of Canada webpage about what a form might look like. But you'll see it's those same kinds of informations that are requested. And so some employers will use this form or use this template to create their own form. Okay, so informing the parties. So within 7 days of receiving the notice of occurrence, the employer or the designated recipient must contact the principal party, and they must inform them first that their notice has been received, or if they were not the actual complainant, that they have been named or identified as the principal party. That's in the case where a witness is the one who brought forward the notice of occurrence. They need to be told how to access the workplace harassment and violence prevention policy. They should be told of each step of the resolution process, and I think this is the most important part, and the part where people are always asking themselves what happens next. And they need to be advised that they can have representation during the process. Obviously, in a unionized workplace, what we have is your union rep can attend with you. In non-unionized workplaces, it can be a support person. It can be legal counsel. Normally, the respondent is more likely to be looking for legal advice at that stage, but in any event. And if the notice of occurrence is provided by a witness who's not anonymous, the employer would also contact the witness during that same 7-day window to acknowledge that the complaint was received. And then and it's not the same deadline, but when the employer decides, or it's at the point where they will first contact the responding party of the occurrence, they have to give them this same information. So a different feature about the regulations is that the principal party has the right to end the complaint resolution process at any time by informing the employer or the designated recipient that they choose not to continue with the process. That's interesting to me. It's a significant difference from most provincial legislation in which the employer can, and frankly sometimes must, investigate incidents of harassment regardless of whether or not the complainant wants to proceed. And so normally what that's based on is the principle that an employer is responsible for ensuring a healthy and safe workplace for its employees. So the thinking is that the employer has to look into the matter as soon as they become aware of it, regardless of whether or not the complainant wants to participate. And years ago, I was involved in an investigation where, it was an interesting case where there was a witness who had made the complaint, who had brought forward concerns about harassment in the workplace. The target of the alleged harassment vehemently denied that this had happened. She did not feel harassed. She did not want to speak to me. She did not feel targeted. But in the context of this investigation, there were other things that had happened in the workplace. And so ultimately, without getting into too much detail, there was a finding of harassment, and the complainant, or not the complainant, sorry, in this case would be the principal party, would have wanted to have nothing to do with it. And so this is a huge shift in my view. So another aspect of the regulation is this informal resolution option. And so we heard a little bit about it today. So the principal party and the employer must try to see whether the issue can be resolved informally, so normally by way of a negotiated resolution. So if there's going to be a negotiated resolution, and if it might affect the responding party, then the responding party's involvement obviously would be necessary. And then moving on from that, there's another, they call it an informal, I call it sort of a semi-formal, if you will, resolution process or resolution option is conciliation or mediation. So we all know what that is. So it's where a third-party conciliator or a mediator works with the parties to help them resolve their dispute. So unlike the negotiated resolution, which is mandatory, the conciliation can only happen, obviously, can only happen when both parties voluntarily agree to it, and they also need to agree on who the conciliator or the mediator will be. And, this is it's no surprise. Mediation can't work if both parties don't buy it, right? We all know that. What I think is important to note for you when you're advising members or you're advising your locals, when allegations are related to sexual harassment or to violence or to sometimes where there's a significant power imbalance, it's very important to consider how an offer of conciliation should be made, whether it should be made, what the format of that conciliation might look like. Even if somebody was interested in it, is this one of those situations where it's better to have people not come together in the room at first? Sometimes we all get together, then we split out. So you don't always need to see one another. Because what we need to think about is how it could be triggering or re-traumatizing for the complainant or the principal party. Okay, so formal investigations, right? And this is what we think about when we think about the workplace investigation process. This is sort of the focus of that. So if an occurrence is not resolved by negotiated resolution or by conciliation or mediation, then an investigation under the regulations, the investigation of the occurrence must be carried out if the principal party requests it. So the employer or the designated recipient must provide the principal and the responding party that an investigation will be carried out. So who should do the investigation? The regulation actually restricts who can be assigned as an investigator. So it's expected that the employer and the Workplace Health and Safety Committee, the applicable partner, will jointly develop a list of investigators. And so when a notice of occurrence is being brought forward, the employer normally gets to choose anyone from that list to investigate the occurrence. So if there's no joint list, which sometimes happens, then the employer must either assign an investigator who both parties have agreed on, or they can request a roster investigator and the roster is maintained by the Canadian Centre for Occupational Health and Safety. So what are the requirements? The investigator must be trained and knowledgeable, and they must declare themselves to be free of conflict of interest in respect of the investigation. And then they're also supposed to provide the parties with, their statement of qualifications. So their name, their job title, a description of their knowledge and training, and also a description of any specific experience that they might have that fits in with the nature of their occurrence. So, for example, specific experience in intimate partner violence or in sexual harassment or internal union structures if the investigation's happening within a union, or racism or trauma-informed investigations, those kinds of things. So I've got the slide here on the investigation report, but I thought I should also make a quick note about how the investigation process unfolds. So I will say that the investigator is the master of their own process, if you will, in terms of how they conduct the investigation. But when you're advising members, or if you're going through this, a couple things that I tell people is whatever timeline you're thinking, although there are specific timelines, but whatever people are thinking in their head, You might have heard me say this before. I always say multiply by 6. I don't say double it. I'm like, let's set some realistic expectations. People go on holidays, people are sick, union representatives aren't available, lawyers aren't available, whatever the case may be, times it by 6. That's number one. Number two is normally, not always, but normally the investigator will reach out to the complainant or the principal party first. They will interview that person. They will, sometimes they will summarize the allegations. So if the person, provided that 14-page complaint document and nobody wants to just hand that over to the respondent because it contains a lot of extraneous or non-confidential information, or confidential information, but it's not blacked out, for example, or redacted, then sometimes the investigator will do a summary of those allegations, and then that gets provided to the respondent, and then they conduct the interview. And so that's really the opportunity for the complainant to tell their story from start to finish. Normally, not always, but normally after that, the investigator will interview witnesses. And so sometimes the complainant identifies witnesses, sometimes the employer just from the investigator just from hearing the names of witnesses decides who may or may not have helpful information. And the respondent is normally interviewed last. And so sometimes that's extremely frustrating for the respondent who is dying to tell their story. They want to get it out and they want to tell it. And what I try to tell people or tell respondents when I'm advising respondents is you need to have all the information presented to you because you have the right to respond to all the allegations. And the allegations aren't necessarily only coming from the complainant. So patience is key in that sense, and also what you want is the investigator to be giving regular updates, just so that people aren't lost and aren't kind of wondering, 2 months have gone by and I've heard nothing. So when that's all done, a report is created, is provided. So the regulation requires that the entire resolution process, including the investigation, must be completed within a year of the notice of occurrence. And so again, people don't think of, a year is a long time. So people don't think about that. If somebody's absent from the workplace for over 90 days, then that year gets extended further. And just as a general note, the timelines in the regulations are something that you're going to want to keep in mind as you're going through the process. So while it's more of an issue for employers, as union representatives, what we want to think about, what those timelines are, because we want to hold the employer's feet to the fire and make sure that those timelines are respected. So, for example, that in terms of timelines, you've got to acknowledge the receipt of the concerns or the notice of occurrence within 7 days. You've got to start the investigation within 45 days. They have to keep the parties informed of the status of the investigation with monthly updates. And you've got to complete the investigation within a year. So the kicker is that 1 year also of fully implementing any recommendations that are made by from the investigator's report. So that sometimes can feel like a tight deadline depending on the nature of those recommendations. I'm not very great at looking at the time. Oh, not bad. Okay, all right. So back to the report itself. The regulations have very specific requirements about what that report can look like. So the investigator has to describe the circumstances in the workplace that contributed to the harassment. They have to make recommendations on how to prevent similar occurrences. And so investigators have to kind of turn their minds to systemic and workplace culture issues. The investigator cannot reveal the identity of the parties, so that can be extremely challenging. Investigators need to be cautious about how they write their report, so sometimes the most careful of redactions will still reveal enough information that any of the recipients can kind of piece together who did what to whom and who testified what and who gave evidence against them, right? And so describing things like titles or relationships or departments that could reveal the identity of the parties. The employer has to provide a copy to both the complainant and the respondent, as well as to the applicable party. And what you should know about here, because what we're finding is happening, is that investigators under this regulation are being asked to basically create 2 reports. And so there is one that is the report, and what I mean by that is there's one more detailed report, and then there's a second summary report. And the summary report is quite often what's being given to the principal party and the responding party, and then a select group, whether it's in HR or whatever the case may be. There's only a very limited number of people who see the entire report. So what I have included in the materials that will be sent to you are sample redacted copies of an English report and one in French. And so you'll kind of get a sense of what that will look like. Those are both summary reports. They're both, in the 5 to 10 page kind of range. They need to give enough specificity and enough detail that people know what happened in terms of what were the allegations and what was the outcome, but they will not have all of the details of the larger report, which, can sometimes be 75, 100 pages long. And I'll hold my own opinion as to whether or not, complainants or respondents should be entitled to the whole thing. Okay, recommendations. So, discussing and implementing the investigator's recommendations. So once the investigation is complete, the employer and the Workplace Health and Safety Committee or the representative must jointly agree upon the recommendations that are made and what will be implemented in the report. So once those recommendations are agreed upon, the employer has to implement everything that has been agreed upon. And if they cannot agree about whether or not a particular recommendation should be implemented, then the employer has the final say. But the employer then has to provide a written explanation of why or explaining its decision not to implement the recommendation. The regulation also requires employers to make a report, to report once a year to the minister, and they have to outline the total number of occurrences, so complaints, details on the number of occurrences that were related to sexual harassment, non-sexual harassment, and workplace violence. The types of relationships between the principal parties and the responding parties. So was it a supervisor-subordinate relationship? Was it colleagues? Was it, whatever the case may be? The methods of conflict resolution or resolution that were employed. So did these things settle at the informal stage, at the mediation stage, or did they go through to a full investigation? And then the average time it took to resolve to go through the entire resolution process. Okay. I'm just trying to figure out how I'll do this with the translation. I can say it in English. It may be a little bit easier to start this way, and then by all means, I don't want to take up more time than I'm allowed to. But come to see me after, and I'll share it all again in French if you like. So one of the things that I was asked to speak with you about was to give some practical tips to consider when you're approached by a member or who's either alleging workplace harassment or violence or who's the respondent in those types of allegations. So as the union, you want to counsel locals, stewards, and representatives to avoid taking sides or exposing the local to a conflict of interest situation. So in member-to-member conflicts, it's almost always best to assign separate representatives or to engage outside counsel for one of the members. And we have run into, maybe you have run into, I've certainly run into in my practice, places where it's a small local or it's a small group, and somebody has to recuse themselves, but then kind of sits in the background and still, needs to know the information and find out, and that's just problematic. So separate those things and create an information wall where people are not speaking to one another about people. When I say people, I mean representatives. Are not speaking to each other about the details and the pros and cons of each side, unless, of course, it's in the context of negotiating something, and or engage outside counsel so that there's a real distance between representatives. So as the representative, something else to keep in mind when we're talking about harassment and workplace violence is you want to assess your ability to undertake the role. So if you're dealing with allegations of, for example, racism, sexism, ableism, homophobia, transphobia, consider whether you have the knowledge or the understanding that's required. And if you don't have it, then seek input from somebody who does. So we don't all have the same shared life experiences, so lean on somebody else who has those experiences. You also want to consider whether there's a power imbalance between the two members or whether the allegations are serious. And although allegations are important to the complainant, but the level of seriousness of the allegations may impact your approach to the problem. And I go back to the example of in a sexual assault situation, this is not likely a place where you want to put two people together at a table to work it out. Think about also not only filing a complaint, but whether a grievance is appropriate in the situation. So for example, when harassment is based on a prohibited human rights ground, you might be thinking of grievance, complaint, and human rights complaint. All of those things are things to keep in mind and to think about the time limits for doing all of those things, which are normally different. Okay, and more specifically with how to help a member that comes to you with allegations of harassment or violence. So these are the types of questions that might be helpful to you if you're interviewing someone. If somebody is coming to you and talking to you about these things, this might help you help them in understanding what happened and putting their complaint together or formulating their own mind how to put the complaint together. So what were the dates, the times, the places of the alleged incidents? What kind of harassment was it? So was it personal, racial, sexual, or some other type? Was there physical contact? Did the member feel unsafe? Was the member denied a promotion? Was the member subject to discipline? Was the member subject to a toxic work environment? So, and are there physical or mental health effects of the alleged harassment? So another question to ask is, did the member do or say anything to show that the harassing words or actions were not welcome? So listen, it's important to note that a member who has been harassed does not have to object in order to have a valid harassment complaint. You're not required to tell the person that their conduct is unwelcome. Normally the test is conduct that is known or ought to be known to be unwelcome. But nonetheless, it's important for you as a representative to know whether or not something was said, and that's when you're building your case for harassment or violence. Who's the alleged harasser? So is it a supervisor? Is it a coworker? Is it someone the member deals with as part of his or her job? Are there witnesses? Who are the witnesses? What did those witnesses see and hear? Because you'll often get people who want to give character witnesses or who know about stuff that happened 16 years ago or whatever the case may be. And what you need to know is who saw this? Who saw this happen? Because that's who likely the investigator needs to speak with first. Sometimes context is important, but people think it's more important than it is in terms of, I'm a really good person, and so I wouldn't do this kind of thing. You actually see that from respondents coming, more often from respondents than complainants. So are there documents related to the harassment? These days, what we tend to see are emails. So people will come to us with a binder full of, 200 emails that they have, have been in receipt of, and they've kept them all. But that's helpful for the investigation. Has it happened more than once? Is this a single incident or is this a recurring pattern? Often, unless it's a single serious incident, most of the time when you're dealing with harassment, what you're seeing is a pattern over time. So things don't come out of the blue. They really do happen sort of slowly but surely, and at some point somebody hits the tipping point. And has the member informed management of the harassment or the workplace violence? And if yes, what was done, if anything was done? Donc, écoutez, je pense bien.
So listen, I think that we've reached the end here. I think that you've heard enough from me, and I hope that this presentation has given you a sense of what you can expect in the context of the complaint process under the Canada Labour Code, and as to how you can help your members. The key takeaways are to listen, to get their story, to not rush to judging the situation, to not put yourself in a situation of conflict of interest, and always think about the time limits. So thank you very much.
Questions, and I'm sticking around. I think you guys are heading to a break. No, not heading to a break. I'll stick around, and if anyone wants to come up and chat, I'm happy to do that. Thank you.
So the way we're going to do this, we don't have any standing mics because we didn't want people going to one area. So if you have a question, just raise your hand, and Colleen or myself will bring you the microphone. Thank you.
Hi.
What happens if you submit a notice of occurrence and you don't actually get the response that you would expect or want from the employer?
So under this new legislation, what they have to do is acknowledge that they've received it. What you tend to see more actually is just a delay in terms of things getting going, but the initial response is really an acknowledgement of receipt, right? And it's a copy of the policy that's applicable to the situation, and that's about it. And then what you do is you get that letter that says, we're going to turn our minds to this, and we'll get back to you. And so what I think is important is for union representatives in particular to be pushing the employer at that point. If nothing is happening within, a week or two, you need to be following up and saying, what's happening next? I understand that there's an informal resolution process. Is that where we're at now? Is a negotiated settlement being looked at? If not, let's move on. And I think that's what you have to do. You have to be pushing that forward. If the employer refuses, if nothing gets done, then you've got options such as a grievance, right? Of course, a grievance for failing to follow the process. So whether that's a policy grievance or whether that ultimately becomes a health and safety grievance for the individual. And also there are penalties for employers failing to follow the regulation. So if the employer is not following the regulation, you can report that to the ministry. And I think that the initial approach is always voluntary compliance, and then ultimately, if there's continued non-compliance, then there can be fines, and the employer's name can be published. Yeah, so that's always a good threat. Any other questions?
Yes. Two questions, if I may. The first one is about the investigator. It seems that this is a common feature of the process. Mm-hmm. Who bears the cost? Because presumably investigators, if they're skilled, come with a pretty high price tag.
It's very funny that you say, so the short answer is normally the employer. And so it's funny because that question is sometimes asked of me as an investigator when I'm wearing my investigator hat. And all I know from my end is I'm retained by an employer. So in this case, it could be UCTE as the employer would retain me and would pay my bill. And now I do know that sometimes there can be internal arrangements between employers and their own unions that are within the workplace, but I've not seen it happen. I just know that it could happen. So whatever happens internally, that's one thing, but the employer is expected under the regulation to bear the cost of the investigation.
Okay, thank you. And my second question is, you refer to the reports and you say they're sort of anonymized.
Yes.
Do they ever find their way into any sort of publicly accessible location?
So,
thank you.
Some of your employers are subject to ATIP legislation, right? Or the privacy legislation, whatever the case may be. I always so they're not supposed to. They are supposed to be sort of locked away. But I always tell people when I'm in a workplace that is subject to ATIP, for example, that, listen, what we talk about, you might want me to send you that on your personal email. You might want me to send you my own investigation notes on a personal email rather than a workplace email. And because there's always that risk. It's not supposed to come out, but if it does come out, that's the purpose of it being completely anonymized. It also, even before this regulation, I always anonymized my reports. I do it more carefully now, but I always anonymized my reports and named, complainant 1, respondent 1, witness A, B, C, D, E. And the reason for that is I don't want somebody, it gets locked away in a cabinet and then staff can change. And then what I don't want is somebody 5 years from now pulling open the cabinet and sort of, reading through the report and knowing something that a complaint had been made against a fellow coworker 5 years before. So you try to avoid it, but I never promise, ultimate anonymity or confidentiality to anyone. I think, that's it. All right. Okay, so thank you. I'll hang around, but thank you.